So good afternoon, everyone, and welcome to Elder Abuse Prevention Ontario's webinar series on the rights of older adults. We are pleased today to be hosting a presentation today on protecting the rights of residents in long-term care, the right to being safe and secure. Just to go over some housekeeping issues before we get started with our webinar. Everyone will be muted during the webinar just to keep it quiet for our speaker. It is being recorded and will be posted on our website probably in the next couple days. We are pleased to have Asl Interpreters join us today. We have two individuals who will be switching off during the presentation. If you'd like to make the presenters or Asl Interpreter larger on your screen, you can pull the black bar on the left-hand side of the picture across to make the picture a little bit more visible for yourself. We will be having a question and answer period at the end of the session, so we would encourage you to put those questions in the question and answer box. My colleague Laura Proctor will be answering those at the end of the session, and if she's able to answer a question during the presentation, she will type that in, but we will hold questions to the end. If you have a comment or just something that you would like to say something to another colleague that might be online, you please put that into the chat box. And we will have an evaluation pop up after the webinar just to get your feedback on this session as well as your ideas for future sessions. We do appreciate taking a few minutes doing that. It does give us some really good feedback in how we can proceed and improve future webinars for yourself. And I know the contact information is available for our speakers as well as our organization at the end of the session, so you can contact either Elder Abuse Ontario or Advocacy Centre for the Elderly. Now I'd like to turn it to my colleague Laura to do the land acknowledgement.
Thank you, Rayanne. EAPO endeavors to honor the land and its treaties by strengthening our relationship and responsibilities to them. We live and work on Métis, Anishinaabeg, Ojibwe, and Cree territories. The presence of settlers is not neutral, and it has continued to have devastating impacts on many aspects of life for Indigenous peoples. Many of our practices, including the way we care for our elders, the ways we educate, and our methods of creating community, came to these lands through an ongoing process of colonialism. We now hold a new understanding in our interactions and engagements with this land and its people. There is important work being done by many nations and allies to ensure the continued thriving of all communities and knowledge systems. Those of us who are settlers need to recognize that our way and the way of doing things may not be the priority as we work towards a safe Ontario for all seniors.
Thank you, Laura. I just want to give a couple slides of introduction to our organization, Elder Abuse Prevention Ontario, for those who may not be familiar with our agency. Our mission is to make sure seniors are free from abuse, have a strong voice, feel respected and safe. We've been in our organization doing this work for over 20 years, and our action really is to provide education and training, and with other organizations working with seniors in service coordination and advocacy. And we've been mandated to implement Ontario's strategy to combat elder abuse back in 2003 under the Ministry for Seniors and Accessibility. So we're pleased to continue that strategy today and provide you these education sessions that we host throughout the year to provide that further information into your hands so you can prevent this or recognize situations that might come to your attention for others that might be at risk or experiencing abuse. We work with many community partners in our coordinating community response, including the Advocacy Centre for the Elderly, and we work together to find solutions to look for different approaches to respond to elder abuse. And again, as I mentioned, we do training and we do a lot of public education awareness, and many people may be familiar with World Elder Abuse Awareness Day, which is in June 15th, where we do a lot of promotion on that day, particularly for education awareness. But you can follow us on Facebook, where we do constant awareness and education about different issues. And it's no surprise to many people, COVID has increased the vulnerabilities for older adults, putting them at increased risk of abuse. And it is unfortunate that we've seen this happen. We know the work that we've been doing has been going on for many, many years. It's unfortunate that COVID has kind of put it into that spotlight for us, where it's come to people's attention, whether that's on the media through TV and radio, It's in people's living rooms now. We're hearing about these unfortunate situations where seniors are experiencing abuse. And it's unfortunate the pandemic has brought this to the forefront, but we know that this has been going on for many years, and we need to combat it and making sure that seniors are safe from abuse, which is why we've invited Jane Meadus today to speak with us about the legal issues about the rights of older adults, because we know that that's been in the media quite a bit. And I know there's many of us joined today that have maybe loved ones in long-term care, looking for some answers and have lots of questions about the legal rights of residents, and as well as for family members. So Jane, I've known for many years, and a great advocate. She's a staff lawyer and institutional advocate at the Advocacy Centre for the Elderly. She represents clients in long-term care homes, as well as hospitals and psychiatric facilities and retirement homes with related issues around the legal aspects related to seniors. She has been lots of work in housing, financial estate planning. I know that she does courses to train other lawyers around these important issues. And she's a distinguished fellow at the Canadian Centre for Elder Law Studies. So it gives me great pleasure for Jane to show her expertise and share with you today. Some of you may have seen her on television, and she's done many interviews around this issue that we're talking about today. So I'm just going to stop my screen and have Jane start her presentation.
Thank you. So hopefully we'll get this done properly. Here we go. Okay. All this technical stuff here. Okay, well, thank you for inviting me today. I'm looking forward to this presentation. I guess one of the things that I just will say is that I do have a lot of slides. If I don't get through them, they will be presented, provided to the attendants, so that you can look at them and hopefully get some information from them. So I realize that I may not get to the end of it because we do want to leave quite a long time for questions. So we'll see how far we can get, but you will get the materials afterwards. Okay, why is that not working? Oh, there we go. Just to let you know that this presentation and the materials are not legal advice, but legal information. Legal issues are fact specific and require factual information in order to provide legal advice to resolve the issue or problem. And so just be aware that if you require legal advice, you have to get your own lawyer. So I'm just going to first talk a little bit about sort of where we are and what kind of homes that we're talking about here. So I'm going to be presenting particularly on long-term care, but just so that we all start in the same place, because I think there's a lot of confusion in the public sector about, so what homes are and what they provide. So long-term care homes are publicly funded healthcare facilities. There's three types: municipal, nonprofit, or for-profit or charitable. Admission is through the land, and they're licensed and inspected by the Ministry of Long-Term Care and governed by Long-Term Care Homes Act. Retirement homes are tenancies. They are not health facilities. They are like an apartment with care. They're private pay. So you have a lease and a contract. You make your own they make their own determinations about who lives there. And they're licensed and inspected by the Retirement Home Regulatory Authority and governed by both the Residential Tenancies Act and the Retirement Homes Act. There's other types of congregate living, so assisted living, group homes, domiciliary hostels. They have their own, possibly their own legislation that deals with them, sometimes not. There's also sort of a gray market area of homes that are set up that have no legislation, no licensing. And so the landscape can be quite confusing. We'll talk a little bit about COVID. So in COVID, there's many pieces of legislation that are really important. But when you're dealing with sort of seniors, the things you're going to look at are the Long-Term Care Homes Act, the Healthcare Consent Act, Substitute Decisions Act, Personal Health Information Protection Act, Health Protection and Promotion Act, Emergency Management and Civil Protection Act, and the Retirement Homes Act. It gets very complicated as there's been many regulations passed related to COVID, which may relate to the various pieces of legislation that I talked about or other types of legislation. With respect to Long-Term Care Homes Act, there's been regulatory amendments, so changes to the law around admission, discharge, readmission, staffing, waiting list, something called direct access beds, and accommodation fees. So, you know, things have really changed during COVID. And it will be interesting to see when COVID is done, how much of that goes back to what we saw before. Retirement homes, as I indicated, are not health facilities. They're not part of our healthcare system. However, the government passed a regulation that said that the same policies and directives that relate to long-term care homes also relate to retirement homes. Now, there are differences when it comes to absences and visiting. I'm not going to go into those in detail, but they do have different policies with respect to those. But other than that, they generally have to follow the same directives and policies specific to COVID. There have also been special amendments through the Emergency Act. So work redeployment. So that was, you know, hospital workers being redeployed to long-term care, for example. Agreements between health services providers and retirement homes. So they were able to take people who are waiting in hospital for potentially for long-term care and put them in a retirement home, and limiting employees' work to a single home. And those were all done under the emergency legislation. We also have a slew of different kinds of acts and policies that relate to COVID. So this is by no means an exhaustive list, but when you're talking about long-term care and sort of general issues, these are some of the things that you need to know about. So there are federal legislation, and that would be under the Quarantine Act and the Aeronautics Act, and that relates to international travel. In Ontario, there, you know, we have orders. So the Minister of Health has had orders to do with the supply of PPE. We have the Chief Medical Officer of Health and local medical officers of health who can make orders under Section 22 of the Health Protection and Promotion Act. These can be class orders against a group of individuals. So for example, many areas have a class order that say if you have COVID or have been exposed to COVID, that you have to stay at home and isolate. You can have individual orders against a specific person or entity. So there, example, if you've been following the news, there was a recent Section 22 order against the owner of a barbecue restaurant who was opening contrary to the policies and government directives. So there was an order, and that's how they were able to arrest him. Respected people. So if a person has been exposed and refused to isolate, there could in fact be a order against that person to be detained. And then if they refuse, then they would could be arrested. So those orders allow for forced isolation, detention, for example, where a person has been exposed to or has an infectious disease. There are also directives under the legislation, and these are some of the most important things when it comes to the long-term care homes and retirement homes, for example, and health facilities. And these come from the Chief Medical Officer of Health, and he issues directives. The Minister of Long-Term Care also has the authority to issue directives around operation or policy issues, where she believes it to be in the public interest. So we have five directives. So we have 5 directives from the Chief Medical Officer of Health with respect to health facilities. And the one that's most important is to us is number 3, which is the directive to long-term care homes and retirement homes. Long-term care homes are also affected by directive number 5, and that has to do with PPE and infection control. And you can see that it is very difficult to sometimes keep track of the landscape. If you look at directive number 3, those are the different iterations of the directive that we've had, then the most recent was October the 14th. So it is a daily struggle to keep up with these rules for those of us who are watching, let alone for the public who are trying to figure out what's going on in homes and how they can best care for loved ones. There has been a minister's directive for the Minister of Long-Term Care supporting long-term care homes, and then the surveillance, testing, and access to homes, which was the most recent minister's directive. There's a lot of guidance documents and resources as well. Probably the most important for long-term care would be the visiting and the absence directive guidance documents, and so those are available online, but again there are pages and pages of documents. Just the names of the documents, let alone the actual documents, are quite difficult, and they do change depending on what is happening. So Long-Term Care Homes Act, the first thing you need to know is the fundamental principle, which that principle is applied to the interpretation of the act, anything required or permitted under the legislation, that it's primarily the home of the residents, and it's operated so that it's a place where the residents can live with dignity and security, safety and comfort, and have their physical, psychological, social, spiritual, and cultural needs met. The Long-Term Care Homes Act also includes a Residents' Bill of Rights, which has 27 rights. The Act states it's enforceable as a contract, so if the home doesn't comply, you can actually sue them in court over that as a breach of contract. And it's supposed to guide the interpretation of acts and regulations, agreements between the licensee and Crown agencies, and the agreements with the licensee and residents or substitute decision makers. As I said, it can be enforced as a contract, and the government can set out how regulations are to be respected and promoted by the home. And those rights would also be enforced through the compliance system, so the inspections. A lot of people, I think, have a lot of questions about complaint processes in long-term care, what they can do, what they can't do. So all homes have to have a complaint process and that has to be provided to the resident or their substitute. So they have to provide you that in writing. You can use the process, but it's not mandatory. So if you have a complaint, you can always go, for example, directly to the ministry, and you don't have to go through the home's process. Often home residents or substitutes are told, oh, you can't go to the ministry unless you've gone through our process. And of course, that's untrue. The home has to investigate and report on complaints, and complaints in writing have to be provided to the ministry. You can make complaints to the Ministry of Long-Term Care. Allegations of abuse and neglect, there's mandatory reporting to the Ministry of Long-Term Care by anyone except for the resident. So if you are aware or suspect abuse or neglect in a long-term care home, it's mandatory for you to report that to the Ministry of Long-Term Care. And you can do that through the action line, which is the same place you make any other complaints to the ministry. The ministry has the duty to inspect homes and prepare reports, and all reports are publicly available online, and I've given you the address there, but if you just search Public Report Long-Term Care Ontario, you will find them. And you can see every report since 2010 is, I believe, posted there. You can make complaints about long-term care homes, hospitals, and home care to the patient ombudsman. They look at situations and see if they can help resolve it, but they don't take sides. Complaints must be made in writing to the patient ombudsman. And the patient ombudsman will only take it if you've attempted to resolve it with the home. So you can't, it's a last resort, not a first resort. If you have a complaint about a health professional, such as a doctor or a nurse, you can make a complaint to their colleges. Personal support workers are unregulated, so there's no body to complain to. However, sometimes you can make a complaint with respect to a personal support worker, but you make the complaint about the nurse who is supposed to be supervising. So if the personal support workers are not being properly supervised by the nurse in charge, that could be a complaint against that health professional. The Ontario Ombudsman is there to investigate complaints about government action, and they can investigate complaints about issues such as inspections by Ministry of Long-Term Care. So if you believe that a complaint you made was not investigated properly or fairly, that complaint can be made to the Ontario Ombudsman, but you do have to speak to the Ministry of Long-Term Care first. So you do have to resolve it. Again, it's a last resort. So if you think that the ministry, either didn't take your complaint seriously or didn't investigate it properly or thoroughly, and you ask the ministry to review it and they say, no, we've done our job, you could complain to the Ontario Ombudsman. We get a lot of complaints or questions about access to records. And I will be talking a bit about this later, but if you have a right of access to your records as a resident or as a substitute decision maker, and you are not getting access to those records, you can make a complaint to the Information Privacy Commissioner of Ontario. And they also oversee access issues with respect to municipalities and the provincial government. So if there's an issue relating to access, so you've requested access to records and you're not getting them, or if there's been a breach, so if information has been shared or somehow given out without authority, they can review, investigate, and assist in resolving. And in some cases, they will actually, sort of do a more formal process, and they can make orders for a health information custodian to release information. With respect to long-term care, I think for the most part, it's usually requests for information where the home is failing to provide that information. And in those cases, usually it can be resolved fairly quickly by an early resolution officer who will contact the home and find out what the issue is. Often the issue, frankly, is that the home doesn't know that it has an obligation to provide that information and doesn't know what they're supposed to do. If you're interested in how to access information, the Information and Privacy Commissioner does have a lot of information on their website. And in fact, it actually has an information sheet on how to access information in long-term care homes. And it's not because there's anything special about it. It's because our office had so many problems and ran into this for so long and had homes just refusing to release information that we encouraged and got the Information and Privacy Commissioner to put out a bullet, an information sheet to make it very clear that these homes have to comply just like any other health information custodian. Retirement homes are also health information custodians. So if you have health records there, those records would also be governed by this act. It governs any kind of records, whether it's your masseur, your doctor, your dentist, any kind of health information records. So what kind of issues do we run into, especially during COVID? So issues around consent to treatment, resident absences in detention, visitors, PPE, compliance and inspection, and trespass orders. One of the things that I want to make very clear is, whose rights are we talking about? And a lot of the time we get a lot of calls about what are the rights of the family. Generally, the families don't have rights. It's the rights of the resident. So the rights come out of the resident's rights. They're not specific rights to the family. Where a resident is not mentally capable, the substitute decision maker, or SDM, may have the authority to execute those rights on behalf of the resident and may also have rights on their own as the substitute decision maker. So, for example, families do not have a right to visit. Residents have the right to have visitors. And so it's a little bit of a distinction there. So consent to treatment, this has been a big issue during COVID especially, but frankly, it's always a problem in long-term care. Frankly, it's a problem pretty much anywhere in the healthcare system. Unfortunately, I would say that healthcare practitioners, for the most part, are not properly trained in what the rules around consent are and what their obligations are. So we really run into a lot of problems throughout the health system, but specifically in long-term care, where people may not be able to speak up for themselves because of capacity issues, or just because they're afraid to speak up because they're living in the place where they're getting health care. So the Healthcare Consent Act is the legislation that governs consent issues in any health sector in Ontario. So it covers 3 areas, basically. So consent to treatment, consent to admission to a long-term care home, and consent to personal assistance services in a long-term care home or retirement home. And those are sort of your activities of daily living. The Act defines capacity. It requires informed consent for any kind of treatment. It sets out the rules for substitute decision-making on behalf of an incapable person. So who makes decisions if a person's incapable, how they're to be found incapable, what it means to be incapable, that sort of thing, and applications to the Consent and Capacity Board. So we're very lucky in Ontario that we have a board that people can go to if, for example, they disagree about the kind of being found incapable, that they can have people appointed if they don't have an attorney or guardian. Somebody can apply to be their decision maker if that person is incapable and doesn't have an attorney or guardian. There's a whole bunch of other things that can be done to the Consent Capacity Board. This doesn't exist in other provinces, and people would have to go to court. And of course, that makes it much more difficult. I am not going to be going through the consent laws specifically. That's a whole lecture on itself. But there's certainly lots of information out there about consent capacity rules. So the rules during COVID are no different. In order to treat anyone, a health practitioner who is offering the treatment must obtain informed consent from the capable person, or if they're incapable, from their substitute decision maker. So the health practitioner doesn't necessarily have to do it on their own. They could have another health practitioner do it for them. So for example, if a doctor was ordering a treatment in long-term care, the nurse could get the informed consent from the person, but they have to be able to provide all the necessary information. They have to be able to answer the questions and then get informed consent. Capacity of the resident has to be determined before they go to a substitute. So the doctor can't say, well, we'll just go to the substitute because, well, they live in long-term care, so they must be incapable. They actually have to put their minds to whether or not a person is incapable. And everyone is presumed to be capable unless there's been a finding of incapacity. If the resident is incapable, the health practitioner must obtain informed consent from a substitute decision maker, and it can be done by telephone or other electronic means. It is not a signature on a piece of paper. We'll talk about that later, but it doesn't, just because somebody signs a piece of paper does not mean that they've given informed consent. It may be evidence of informed consent, but it is itself not necessarily informed consent. The only exception to obtaining informed consent would be in an emergency if a delay would prolong the suffering of a person or put them at risk of serious bodily harm. The Healthcare Consent Act defines who substitute decision makers are. The health practitioner generally has to go to the highest person on the hierarchy. If there's a guardian or attorney, they must go to those persons. There are some exceptions if it's a lower person, and we're not going to get into those details, but generally they should be going to the highest person on the list. There's an obligation of the health practitioner to contact them for decisions. So when we were dealing with COVID, and we were hearing about, people didn't know what was going on in the homes. They didn't know what kind of treatment was happening. People were, going off and, they didn't know if their person had COVID, if they were getting treated. That would, if the resident was capable, of course, they make their own decisions, and the families are not, would not have to be informed. There are requirements under the Long-Term Care Homes Act to inform a family member or another person of importance if the resident has authorized that. But if someone is a decision maker, so, the whole family is not the decision maker, but whoever the substitute decision maker would be on behalf of a resident, if that resident is incapable, the health practitioner had an obligation to talk to them, to tell them what was going on, to tell them what kind of treatment they required, and to advise them if they were not offering treatment. So, there was no difference during COVID. I think the difference was that we had a breakdown of the system. We had people, not enough staff. And so one of the things that fell apart, of course, was the substitute decision making. This is, however, not uncommon in non-COVID times. Families who are not particularly involved in their family member's life and the person is incapable, it is not uncommon for homes never to get informed consent. That doesn't make it right, but I would say that is a fairly common thing to happen. So this is the hierarchy. So everyone in Ontario who is incapable does have a person who is their substitute decision maker. And this is a simplified version. It is a little bit more complicated than this, but this gives you the general idea. So it's the guardian of person appointed by court. Very few people in Ontario would have one. An attorney for personal care appointed under a power of attorney for personal care. So the power of attorney is the document, the attorney is the person. You can, as I said, have a board appointed representative. Then it would go to a spouse or partner, child's parent, parent with right of access, doesn't usually, that's not an issue in long-term care, of course, a brother, sister, any other relative. And then if you have absolutely no one, it's the public guardian and trustee. So everyone has someone to make a decision for them in Ontario. We get a lot of questions about capacity assessments. And, when do you hire a capacity assessor? Generally in long-term care, unless there's issues around property, you would not hire a capacity assessor. So it's up to the health practitioner offering the treatment to evaluate the person's capacity to consent to treatment, the treatment being proposed, not a capacity assessor. Even if the person was incapable with respect to admission, or if they're incapable to manage their property, if they're incapable to consent to another kind of treatment, it does not mean they're incapable to consent to the specific treatment being proposed. Capacity to consent to treatment is issue specific. It could be time specific. Think, for example, if you were in a car accident and you were unconscious, your substitute decision maker might make a decision for you. But once you were treated, you would become hopefully conscious and capable. And of course, then you would start to make your own decisions. And it's no different from anyone in long-term care. Capacity assessors really only have very limited legal authority with respect to personal care. And that's when it's a non-Healthcare Consent Act issue. So if it's under the Healthcare Consent Act, it's always the health practitioner or whoever's named in the Healthcare Consent Act that makes the determination of capacity. But if there's a power of attorney for personal care where confirmation of incapacity is required, and that it either says it has to be a capacity assessor or it just says it has to be confirmed but doesn't say by whom, that's when a capacity assessor would come in. There is a role for capacity assessors if someone doesn't have an attorney for property or a guardian for property, and they need someone to manage their property. That would be the most common thing capacity assessors would be brought in for. Other than that, anything is an opinion only and doesn't have any legal authority. If a person is incapable, the substitute decision maker must make a decision on their behalf. And they're either required to comply with a known wish applicable to the situation. And if not, they have to make the decision in accordance with the best interest test. And that test is set out in the Healthcare Consent Act. So you can't just make the decision that you think is the best. You have to do it in a way that that person, you are acting in their best interest and with respect to their values and beliefs, not your own. Accessing documents is a big issue. So access to health information is governed, as I said, by Personal Health Information Act, or PHIPA. The individual has a right of access. So I have a right of access to my own information. And I can also grant access to my information to someone else. And so I could write a consent form. And for example, as a lawyer, this happens all the time where I will request that my client authorize me to access their records for the purpose of representing them. If the person's incapable of consenting to the release of information, so that would be a finding by the health information custodian, or if they're incapable with respect to a decision under the Healthcare Consent Act and a substitute's made a decision on their behalf, then the substitute would have authority to access the personal health information. So if you're a substitute decision maker and you have made a decision on behalf of an incapable person, you would have access to their personal health information as well. And so in some situations, both the person and the substitute would have access because the person would be capable of some things and the substitute would be making decisions in other areas. If access to the information is required to make a decision under the Healthcare Consent Act, that information should be provided when requested as part of the informed consent process. If the request for information is made for another purpose, then the health information custodian has 30 days to provide the information. And if they're going to refuse the access or give only partial access, they have to tell you what the reason is under PHIPA. And there is a cost for copies of records, $30 for the first 20 pages and 25 cents per page after that. And that's for photocopies. With respect to, some of them do it on discs now or on USBs. Other kinds of records, there would be different charges. In long-term care, we see a lot of advanced care directives and level of care forms. These are not consents. They actually speak to the substitute, and it's up to the substitute, not the physician or other health custodian, to determine what those things mean. And they also can't be signed by a substitute. And I would say probably the vast proportion of level of care forms in long-term care are signed by a substitute. And so they have absolutely no validity whatsoever. Often these documents are signed without, context or discussion. They will have 4 or 5 choices. And of course, there's more than 4 or 5 choices in life. A lot of what's in them is fairly meaningless. It's still up to the substitute, of course, to look at them and say, well, what does this mean? It's unlikely that most of these actually could relate at all to COVID because it didn't exist when people signed them. So it would not have any relevance to COVID, and it would be up to the substitute to take, maybe information from them or whatever in making their decision, but there is no correlation because it just didn't exist. Unfortunately, health practitioners have always looked to these documents instead of getting informed consent, and that's been especially a problem during COVID. And the other thing is you can't have blanket consent. So I recently received a document from a facility that basically said that the substitute consented to any treatment that the health practitioner was offering. And of course, you can't do that because it's contrary it is not informed consent. So there's also the DNRC forms. Those are forms that allow ambulance personnel and other people to not provide CPR if that's the wish of the person, because otherwise they have to do that. So we have a lot of system failures with respect to COVID, blanket decisions not sending people to hospital who have COVID, which is not legal. Reliance on the documents instead of speaking to the residents or the substitute, that's not informed consent. And also failing to offer treatment because the person is elderly or sick, and that of course is not legal. I know a big issue is visits, and I'm going to talk a little bit about visits. I know I don't have a lot of time here, so I'll try to go through this fairly quickly. So we have, general visits. You can't go in if it's an orange, red, or lockdown, if the home is on outbreak or the resident is self-isolating or symptomatic. There are rules around ages 14, 2 at a time. You have to provide a proof of negative test within 2 weeks. The home must provide procedural masks inside. Outside, they don't have to provide masks. The home does not have to supervise. I know a lot of them do, but they're not required. And every person is entitled to at least one 30-minute visit. So then we have essential caregivers. There's a bunch of different types, but of course the type that most people are interested are the caregiver type, which is what people are who are family or friends. So the person has to be the age of 18 and older, designated by the resident or their substitute decision maker in writing. There can be a maximum of 2 in the home at any time, and the person can change the designation at any time. The home may not determine who the designated caregiver is. There are times when you can't visit. For example, for some of essential visitors, PPE has to be provided by the home. So if you have gone and seen someone who is symptomatic or self-isolating or is an outbreak, you can't come in for 14 days. When it's a green or yellow level, you have to provide proof of a negative test in the past 2 weeks and a test to not subsequently having tested positive. Orange or red, you have to be weekly tested. There's no limit to the number of caregivers that can be in a home at one time, although some homes are trying to limit that. Maximum of 2 if in green or yellow, and only 1 if they're in a higher level, the home is an outbreak, or the resident is self-isolating or symptomatic. They have to go through at least this minimum training, which is reviewing a document and watching 3 videos. And that's all that's required for the training. Some homes may have other training that would be required as well. Homes must have visitor policies that align with these policies. However, many have made their own more strict policies. Our position is that they can supplement, but they can't override the government policies. But there's a real question as to the enforcement of that. And so some inspectors will say, oh, the homes can do whatever they want. The higher up you go, the ministry has said that they will enforce. So it is a real dog's breakfast out there as to know what's going to happen. But certainly if you're having issues, you should be contacting the ministry. We also get issues where there's a conflict with the local public health department, where they may put out policies that are in contravention of this. However, if they put out an order, that would be different, and then you could challenge the order. But if it's just some kind of a policy, the homes sort of get caught between all the different entities. There's a question about the legality of these rules, because every resident has rights to communicate and receive visitors under the Long-Term Care Homes Act. And legal rules, question is whether or not a directive or a policy can override a law, and whether or not the homes can have their policies. There have been some cases started, but not, there's been no decisions to my knowledge around this issue. We also have a lot of issues around the detention and absences, and our newsletter, which will be published fairly shortly and available on our website, will review some of these issues, the issue of detention and absence. But what you need to know is that since March 22nd, probably around 150,000 to 200,000 people in Ontario have been detained in their homes, including retirement homes, long-term care homes, and other kinds of congregate living. Retirement home residents were allowed out in June. Long-term care home residents allowed out in September. And these are not orders. These are simply directives. So they're not orders under the the HPPA, which would give the authority to detain. And it's our opinion that these directives don't actually have the authority, but it's hard to you know, if you're a resident, it's hard to breach those because you're going to be stopped from leaving. At the moment, residents or their substitute have to submit requests to leave the home for anything other than a medical absence, and the home has to approve them. If they go on an absence, you don't have to be swabbed or isolated when you return. You should be wearing masks, etc. No absences other than medical if the home is in orange, red, or lockdown, or on outbreak unless it's essential. There are also overnight temporary absences. They do require 14-day isolation. And again, we really don't think that these directives are legal. They're contrary to the rule of law and the charter. They could do under section 22, they can do detention orders, but we don't believe that these directives are legal. Saying that and having that implemented are two different things. Lots of issues around Trespass to Property Act. Our opinion is that the Trespass to Property Act cannot be used against visitors if they're proper visitors in long-term care homes. The homes do issue trespass notices and say that people cannot visit. However, residents' rights give the person a right to visit, and they're also occupiers. And under the Trespass to Property Act, people who have a right to visit or have you know, have a right as an occupier to invite someone in, they can't use the Trespass to Property Act. Unfortunately, this has never gone to court in the context of long-term care. So generally what happens is the home will give the person a notice stating they can't come on the property, and if they do, the police will be called. If they breach, so they come on the property, they try to visit, then the police are called, and the police can arrest, issue tickets. And it's up to the person who's banned to challenge it in court. It's usually a fairly minimal ticket, you know, $100, something like that. And unfortunately what happens, fortunately for the people, they get thrown out of court. Unfortunately, we have yet to have a decision on these from courts because they just never get in front of a justice or a judge. The inspection process, always an issue. There are a variety of different types of inspections, including risk focus, intensive risk focus, critical incidents, complaints, follow-ups, and other inspections. I'm not going to go through it, but there is a really big problem right now with respect to the amount of the ability of the ministry to inspect, the type of inspections they're doing, the findings they're making. You know, we're finding that homes where the armed forces went in, where there were huge numbers of deaths, where we're hearing that the armed forces people went in, have PTSD from how bad it was in there, and yet there's hardly any kind of findings against those homes in the recent inspections. And there are no overall, they're not doing the full home RQI inspections, they're just doing some smaller ones. And so it's really quite problematic, the inspection process right now. They are not using their full tools. And, you know, we have good legislation. We need more tools, I think, for the compliance of inspections, but we do have fairly good legislation, but it's up to the inspectors and the government to actually ensure compliance. And that's where there's been a really big problem in Ontario. So I'm going to leave it there because I know there's lots of questions, and so I'm going to answer questions.
Thank you so much, Jane, for that very informative presentation. I don't know if you can see, but we are getting quite a few questions. So let's get to them, because we did want to make it a priority that everyone could have their questions answered. Okay, here goes nothing. Okay, so first question for you, does ACE provide legal advice to families for an elderly person who's being diagnosed with Alzheimer's? Sounds like around where they're choosing to live And of course, ACE may not have the benefit of knowing all of the family dynamics.
So we don't act for families. We act for residents or the senior themselves. If that person is incapable in some situations, we will act through a substitute, and it would depend on the situation. We don't get involved. Like, so if there's a family dispute, we probably won't get involved because it may be a dispute potentially between the substitute and another family member as opposed to the senior. But for example, where people are in hospital and the hospital is trying to kick them out, instead of going to long-term care, we often do take instructions through a substitute. So it really depends on the situation.
Thanks, Jane. So we have decided to go to 2:15. I did want to let the attendees know, since it is so important to get to these questions. Next question, Jane. If a client is abused by chemical restraint, how can he or she have rights?
So, generally, under the Long-Term Care Homes Act, chemical restraint specifically can only be used in an emergency situation. Usually what we're talking about is an ongoing use of something like an antipsychotic. And there are issues. So if the resident is capable, they can refuse. If they're incapable, it's up to the substitute to consent or refuse consent. And very often that just doesn't happen. But there are issues around whether or not the person's incapable, all sorts of things. So there are challenges that can be made, for example, to the Consent Capacity Board or complaints. But, if you find out that your family member who you're the decision maker for and that person's not capable and they're being sedated or being given an antipsychotic and you haven't consented to that, that is illegal. And you can actually go to the College of Physicians and Surgeons and complain. But I would suggest that you get legal advice.
Next question, Jane. How can a family go ahead and sue a home on behalf of their loved one? Sometimes these lawsuits take years.
Absolutely. And, until recently, there have been very few lawsuits against long-term care homes. More recently, there are more lawsuits against long-term care homes, especially during COVID. Of course, they've just changed some of the rules of the game, and we don't know how that's going to come out because it has to be gross negligence versus regular negligence. But there's other things like contracts and things. You would contact a lawyer who does litigation, and they can advise you. It's usually someone in the private bar that will do that. And if you have a good case, the lawyer will take it on a contingency, so you don't have to put money up front. But it does take many years, and that's why people often don't pursue it. And also because depending on what the issue is, you may not get a lot of damages at the end, and so it may not be worthwhile.
Is a directive the same as an order? My friend's retirement home says it's only a recommendation with respect to masks for residents.
So a directive is not an order. The directive is the home must comply with directions, but it's not an order to the residents. And generally, I think that if it's a really big issue, that it would have to be an order. So if, for example, the home is trying to get residents to wear masks and they refuse, then the public officer of health could make an order, a class order against the residents in those homes to wear masks, for example.
So next question, complaining to the ombudsman is not valuable in emergency cases with medical neglect, right? And which avenue would be the best avenue to choose?
So if there's neglect, I think you should contact a lawyer. You could certainly, it depends on what the issue is. It is very difficult to deal with, especially during COVID. It always has been. And, how do you get them to provide, proper ongoing care? It could be a lawsuit. It could be, there's many different things that could happen. It really depends on the situation and what's happening.
Next question, the long-term care home will not give us copies that are being requested. Why not? I assume copies of care plan files?
So if you, again, as I said, it depends on whether you have a right to have access. So if you are the substitute decision maker, you have a right of access to that document. If you are not, if the resident's capable and you want a copy, the resident would have to request that. Or the substitute decision maker if you're not the substitute. So just because you're a family member, you don't have a right of access, but if you are if you are the decision maker, you have the right to get a copy of the care plan. And if the home refuses, I make sure that you do it in writing, request the copy in writing. They do have 30 days to provide it to you, unless you need it for making a decision at that time. And if they're refusing, if you're having problems or they're just not answering you or they're just refusing, you should contact the Information and Privacy Commissioner, who will often, their early resolution people will call the home and say, you're obligated to provide it to the resident or their substitute.
What is the statute of limitations on medical neglect causing death and financial abuse at the hands of the power of attorney?
So generally it's 2 years from the time you find out, but you'd really have to look it up, but generally it's 2 years. There are different limitation periods, but generally 2 years.
What's the home's responsibility in facilitating video calls and phone calls for residents that are unable to make phone calls during COVID?
So there's no legal obligation. Except for potentially around residents' rights. This is part of the problem, is that a lot of this hasn't been really thought out very well. So there's a lot of restrictions that have been put into directives, but not a lot of things like, if you're restricting the person and not allowing them out, what do you have to do to compensate that? And so unfortunately, we can't point to a law or anything like that to say that they have to do it.
So next question, can a SDM direct long-term care to not allow a specific person, for example, a resident's friend, to see the resident? If so, how much obligation does long-term care have to comply with this with limited security and reception?
So it's a difficult question to answer without more specifics, obviously. But in general, you have to first determine what kind of a substitute are you. So do you have a power of attorney for personal care? So are you the attorney for personal care? So that's the first question. If you're just a substitute because you're the daughter, and so, under the Healthcare Consent Act, you make decisions, you wouldn't have any authority at all, because that doesn't come under the Healthcare Consent Act and you wouldn't have any other authority. If you are an attorney or potentially guardian of the person appointed by court, again, as the attorney, there's only specific areas that you have authority to make decisions. So shelter, clothing, nutrition, healthcare, safety, housing. I think hopefully that's all of them. And so the question is, what is visitor? And so it really depends on what the reasoning is. And so if it doesn't come under one of those areas, you probably don't have authority. And attorneys for personal care don't have detention authority either. There are limitations around a power of attorney for personal care as to what kind of authority you have. If the person is coming in, for example, and abusing them, then it could be a safety issue. But if you just don't really like it, or you say, well, they get upset when they leave or something like that, you probably don't have any authority to make those decisions.
Thanks, Jane. How is admitted abuse by the abuser not resulted in criminal charges?
How is admitted abuse?
It sounds like a perpetrator has admitted to abusing a senior and it did not result in any charges.
Well, that would be a criminal up to the police and the Crown, and it depends on the abuse and the evidence and what's happened.
Yeah. If there is 2 SDMs and one SDM is not capable, how should the long-term care home treat this situation for decisions?
So when you have multiple substitute decision makers, all substitute decision makers have equal decision-making authority, and they have to agree. So if, for example, say on admission to long-term care, you have 10 kids and 9 say, yes, we want mom to go to long-term care, and 1 says no, then it goes to the public guardian and trustee. So it's not, a majority rules. However, if one of the requirements to be a substitute is that you have to be capable yourself. So if you say you're the daughter and you're the decision maker for mom jointly with dad on a power of attorney, but dad is now incapable, he no longer qualifies as a substitute. He is no longer capable. So then you would go to just the daughter. So if the person's not capable or they're dead or whatever, you skip them. If there's a power of attorney for personal care and that person disagrees, they would have to go to court. If they are a decision maker, and we see this happen all the time, say the husband is making the decisions and the home says, we think you're not capable, we're skipping to someone else. And he is a decision maker because he's on the hierarchy as opposed to being appointed as the attorney. He could apply to the consent capacity board to be appointed the decision maker. And as part of that, they would determine whether he was capable. So we see that quite a lot where, there's a disagreement between the healthcare provider and they skip them because they say, well, you're not capable. And so we tell them to go to the consent capacity board.
Thanks, Jane. We're getting several questions around the right to put a camera in a resident's room, audio and visual. Is there any obligations of the home in accommodating this installation?
I don't think there's any, I don't think that you can require the home to accommodate it. I don't think you need the consent of the home either. It's not a right to install. I wouldn't say it was a right, but there isn't anything that would prevent you from doing that. If you're the resident, you can put a camera in your room. If you are the substitute decision maker and you're doing it for healthcare purposes, you could also put a camera in the room. If you're the substitute, you have to be very careful if there's roommates and that sort of thing. We do not recommend audio. The reason being is that you could record audio of 2 people that are unrelated. So if you're the resident or you're acting for the resident, obviously conversation with the resident and the person, you can audio tape that. But the problem is, let's say there were 2 caregivers in the room making the bed and they're having a conversation. You must have the consent of at least one party to audio tape. And that is a problem. So we recommend video only, which is of course a problem because we know there's a lot of verbal abuse.
So for a resident safety perspective, is there an obligation for long-term care homes to do fire drills yearly or monthly? They're wondering how often.
Honestly, I don't have that off the top of my head. The answer is yes, there is an obligation. I'm not the fire expert in our office. I don't know that I can't remember what the amount is, but absolutely, there is absolutely an obligation to do fire drills.
And could you just clarify for the attendees the difference between an SDM and a POA?
So a power of attorney for personal care is a document that appoints someone to be a substitute decision maker, and it gives the authority. So I can appoint Laura as my attorney for personal care, and if I become incapable, she gets to make decisions. If I just sort of leave it blank, it's all those things that I talked about would be healthcare, nutrition, safety, housing, clothing, nutrition, etc. So under the Healthcare Consent Act, we have a hierarchy, and that hierarchy is the hierarchy of substitute decision makers. So the hierarchy would be the guardian would be the first substitute, and if there isn't one, then you go to the attorney for personal care, and then you go down the list. So substitute decision makers are decision makers under the Healthcare Consent Act, and they make treatment, placement, or personal assistance services decisions. So an attorney for personal care is the second highest substitute decision maker. But they also could have more authority under a different legislation as well.
Next question, is it legal to create a visitor policy that is in contradiction with the Ontario health policy, such as attempting to schedule essential caregivers as visitors? If not, what is the remedy for the long-term care home if it does it anyways?
So yeah, so this is a question we get a lot, and it's something that we're trying to sort out. We don't have the answer, I would say, totally, because they keep changing the rules. But we think that you can't go over and above. There is some leeway around some of the if the home is an outbreak and different things like that around, scheduling and stuff. But it's not something where there's a really clear road or path to challenge it. But I would contact the Ministry of Long-Term Care.
Jane, could you speak to how better inspections within long-term care could have potentially created some of the COVID-19 outbreaks?
Could have prevented?
Yeah.
Oh, okay. So, part of the problem was that, a few years ago, with the new government, they stopped doing the RQI inspections, and they were doing pretty much only complaint and critical incident inspections. And those inspections are done reactively. So they're done after there's an incident that happens. And so things, like abuse, neglect sometimes, there's things that people see. And then there's mandatory reporting of certain things by the home. And of course, it requires the home to actually report those things. And it requires people to actually complain. Because they didn't do the RQI, which is that sort of whole home inspection, they didn't look at things like infection protocols. They didn't look to see if they had them. They don't look at the infection process in most cases, because those aren't things that people are going to report. And so, from the ministry's own statistics over the years, they always found that, one of the highest issues and problems they found in these RQI inspections was infection control. And it's not something you would find in a complaint or compliance inspection. Or critical incident inspection. So they look at different things and they find different things. And so had they, been looking at things like critical incidents, RQIs, and looking at the infection control, we may have been able to deal with that earlier. I think that there has always been a complacency around infection control, frankly, in long-term care, because we know that there was always flu outbreaks and gastro outbreaks. And I don't think infection control has ever been done well, even though they do have infection control processes, theoretically. But, if the ministry had actually been looking at some of these things before, we might have had better plans in place when the pandemic started.
Thanks, Jane. Next question. Despite all the horrific finding, the lack of action by those in authority, how can we, those involved with dealing with the fallout, help drive change without biting the hand that feeds us?
So I think that, it's very difficult to complain specifically against the home where your loved one is in, because, they still live there. I think it's political action. I think you should be contacting your MPP, writing letters, getting involved in community organizations, whether it be family councils, this Ontario Health Coalition, a lot of organizations who are out there who are, going to the government and asking for changes. And I think that a lot of the issues and the questions that, were provided to me beforehand that we may not get to today, really are political questions, like, why isn't the compliance system better? We need to get the government to fix that. And so you need to go to your local MPP and complain. You need to go to your local, if it's a municipal home, that home is run by the municipality, complain to them. So I think there's a variety of things, but it's often on the political level that we really need to look at.
Two more questions, Jane. What would be the benefit to our seniors in Ontario if all PSWs were regulated?
I think that, the issue of regulation of PSWs is a tricky one. I think they should be regulated. I think they should be licensed. but there's a cost to that. And given the, usually the cost is borne by the professional. So, since we don't pay them very much, it's very hard to say, oh, and, you're going to have to hand over a lot of that money to an organization. But I think that it would ensure it would do some quality assurance. It would allow to have a complaint process, because right now, people who, if they're fired, they can, maybe not go to work in another long-term care home, but they could go to the retirement home sector, go to home care, and it would, you wouldn't necessarily know. So it would be certainly a repository of, make sure people had the appropriate licenses, were properly trained, would be, they'd be able to discipline, have a discipline history. And I think that would be very helpful.
Last question, Jane. Are residents like tenants? Do they have the same legal rights as tenants? If they can't afford to pay in their long-term care home, do they get evicted?
So no, long-term care homes, I just want to say one thing first, is that retirement home residents are tenants. And so they do have the same rights as anyone else who's a tenant, except for apparently leaving their homes right now. But in long-term care, no, they are not tenants. They have different rights. There is no eviction process. You cannot be kicked out of a home for non-payment. It is part of our healthcare system. And the care there is provided free of charge, and that's an entitlement. You're only paying for accommodation. The home can sue you, but they cannot evict you.
Thank you, Jane. I'll pass it over to Rayanne.
Thank you, Jane, for your excellent presentation. I know there's a lot of information that was put into today's presentation. I'm just skipping through the slides to get to the end of the session. There's so many great resources and information that you provided, and I know we weren't able to get to everybody's question today. We will think about if we can do another session in the future in the new year, because I know that there will be continued requests and sort of need for further clarification on some of these issues that are complicated. I think some of the legal aspects aren't they're hard to understand sometimes, particularly if you're in these situations and you don't have access to resources. So I do want to thank you again for sharing your expertise. I know you're a very busy individual with ACE and the organization itself. I did want to just bring to attention some services and organizations. I know Jane alluded to reporting to police a couple times in the presentation. I would encourage you to talk to your local or regional police detachment. Many police services have a senior support officer or someone dedicated to looking at seniors' issues. So when you're calling, ask to see if there is someone that has that specialty. People can call anonymously to Crime Stoppers as well. This is just an example. For Toronto Police, there is a vulnerable persons coordinator on that detachment, but in other jurisdictions, there's similar positions. We've already talked about reporting. Jane talked about where you can report and the phone numbers, just so you can see those again. The Assaulted Women Helpline is still available for individuals to call if they need support or referral. So the phone number is there. It's available in over 200 languages, and they now have a new online chat service that they've just implemented last week. So you can do an online chat to get information as well from our counselor. And there's Jane's contact information again, the Public Guardian Trustee's Office, Law Referral Society has a referral service where you can get 30 minutes of free legal advice depending on the situation. And you can fill out the information that you request online, and they will link you with a lawyer within your area. And then just, if you're needing some support and as a caregiver, I would also suggest going to the Ontario Caregivers Association. They have a lot of really good resources. And also that Jane mentioned, the Ontario Residents Council has an excellent listing of products and materials that they've developed, particularly around COVID, answering some of the questions that might not have been addressed today. So I would encourage you to go to their site. We had done a tool with ACE a few years back around knowing your legal rights. I can post that along with the posting of this webinar as well. So if people want to download that, they can have access to that. But we are producing many resources and tools that go along with the, just in aligning with the COVID issues, but also just in general with safety planning for seniors and the community. So you'll see many tools and resources available. And lastly, I just want to highlight a lot of issues come up today about the human rights of older persons. Tomorrow, we're actually having another webinar looking at the Convention of Human Rights from a not just an Ontario-based perspective, but Canadian and as well as globally. We have a panel of speakers and experts from across Canada that will be participating. So if you haven't signed up for that, I would encourage you to do so. That will be an hour-and-a-half presentation. We will have interpreters available for that. And it will be a short presentation, but then a dialogue with our expert panel just to get some information and have people have opportunity to ask questions similar to what we did with Dean today, because I find that very helpful. So I just want to thank you again, our contact information if you're looking for further information. And we hope that you'll join future webinars, and thank you again for participating today.